So now we come to probably the most important lecture in this course. This is the lecture on sale of immovable property. It's the sale of immovable property that is the linchpin, that is the very foundation of property law, ladies and gentlemen. It is this conveyance of immovable property that usually gives rise to a lot of satellite litigation. You might have a mortgage over a property, you might have a lease, the lessor, right, might sell the property. You, the lessee, are then disadvantaged, right? He sells the property without giving you any notice. He sells the property while he has leased the property to you. Okay, you are the mortgagee. You are a bank, for example. You represent a bank. You're a general manager. Okay, the property over which a mortgage has been created by the borrower, right, in favor of you, the lender, has been sold, right? There's been a sale of that immovable property. What then happens to the mortgage? So the sale of immovable property triggers a lot of litigation. It brings into play a lot of the other provisions of the Transfer Property Act, and therefore we need to have a very firm understanding, a firm grasp of the provisions relating to sale of immovable property in the Transfer Property Act. And the rest of this pretty lengthy lecture is devoted to this concept of sale. What is a sale? What is the difference between a contract for sale and a sale deed? Does a contract for sale create any rights or a charge in the property or over the property, right? How is it different from a sale deed? What are the formalities that need to be met in order to convey property, in order to convey immovable property? Okay, what are the requirements of the Registration Act, the Stamp Act? Okay, we will look at the federal nature of Stamp Act and the stamp duty, basically, the importance of registration, right, the importance of payment of stamp duty and registration. Okay, then we will, in the second part of this lecture, look at the rights and liabilities of the seller and the buyer. What are the rights of a vendor? What are the rights of a purchaser? Okay, we will turn our attention to that in the second part of this lecture. So before we get too ahead of ourselves, let's now understand the very meaning of this concept, sale. Sale is defined in Section 54 of the Transfer Property Act 1882, and Section 54 is on your screen now. So Section 54, sale defined. Sale is a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. Okay, guys, it's so straightforward, right? Even when you're children, okay, you see this around in the world around you, you see transactions taking place. You get a school uniform. What is that? A sale, right? The uniform, like your father or your mother bought you a uniform. Okay, what is that? That was a sale of the uniform. Okay, ownership in the uniform was transferred to you. You paid X amount of rupees for that uniform. So that's a sale. Okay, now how do you make a sale? Okay, a uniform is a tangible piece of property. Okay, it's tangible. Okay, what about a share? A share, right, or shares are intangible. You can't feel them, you can't touch them, but nevertheless, shares are capable of being owned. Such transfer, okay, in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of a reversion or other intangible thing, can be made only by a registered instrument. It can only be made by a registered instrument. Okay, in the case of tangible immovable property, that is your houses, your buildings, your land, basically, right? In the case of tangible immovable property of value less than 100 rupees, such transfer may be made either by a registered instrument or by delivery of the property. So if the value is less than 100 rupees, there need not be a registered instrument. All that will suffice is that the transfer is made either by a registered instrument or by delivery of the property. And therefore, if you're conveying tangible immovable property that is less than 100 rupees in value, then such a transfer, right, may be made by simple delivery of the property. What about delivery of tangible immovable property? When does that take place? Well, delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property, and therefore delivery is complete when the property is delivered from the vendor, that is the seller, to the buyer, that is the purchaser. Delivery from the vendor to the purchaser is complete when, ladies and gentlemen, the seller places the buyer in possession of the property. Okay, and the last part of Section 54, the last para of Section 54, I'd like to read it. I'm going to go into greater detail on this a bit later, okay, but I'd like to read it anyway. A contract for the sale of immovable property. So an agreement of sale is a contract, okay, that such a sale shall take place on terms settled between the parties. However, that contract for sale does not of itself create any interest in or charge on such property. I hope that's clear. Pause it, read it carefully. I'm back on screen. So I've given you a lot of information there in Section 54. You say, sir, how exactly does one go about registering a conveyance of property? If it's tangible immovable property, you have told us, if it's tangible immovable property and the value is more than 100 rupees, you say that it must be registered. How then, sir, must it be registered? Because Section 54 does not tell us how it should be registered. Very good. If you have picked up on that, you're able to follow along. the requirements of registration of tangible immovable property, ladies and gentlemen, are dealt with in the Indian Registration Act, or what is simply known now as the Registration Act of 1908, passed 110 years or so ago. So the Registration Act 1908 lays out, right, the situations in which a conveyance of immovable property must be registered, and it is to that statute that we will be turning our attention to shortly. Okay, but before we do that, let us try and dig our claws into this concept of sale in section 54. What does it say? It's a transfer of ownership, right, in a piece of property in exchange for a price, promised or part promised, or paid or part paid. What does that mean? Basically, you buy, right, an acre of land, an empty acre of land, a plot of land. There's no construction, there's no building on it. You buy a plot of land. That plot of land is quote unquote sold to you in exchange for a price. Let us say the price you pay there is 1 lakh rupees. Because it is more than 100 rupees, that conveyance, okay, that transfer of ownership from the owner of the land to you, the buyer, must, ladies and gentlemen, be registered, in the sense that the terms of that conveyance, basically, the details as to that property must all be contained in an instrument, a written instrument that subsequently will need to be registered in accordance with the provisions of the Registration Act of 1908. I hope that's clear. That's all there is to say, ladies and gentlemen. That's all there is to it. Okay, you're going to buy a property. Yeah, you want to buy a property. What do you need to do? Well, there's a lot of things you need to do. There's a checklist, and I'm going to give you that checklist. But the fundamental thing you must do is, if you are paying more than 100 rupees for that property, and I'm speaking in layman's terms here, if you're paying more than 100 rupees, you're purchasing that property for more than 100 rupees, then your purchase and the terms of your purchase and the details as to the property that you're purchasing and any covenants that run with that property, or any encumbrances or any encumbrance, right, attached to that property. What is an encumbrance? A charge is an encumbrance, right? The bank has a charge, right? I told you in the previous lecture, I talked about collateral. I've talked about collateral in our lectures on contract law part 2. If you're doing the Transfer Property Act without looking at my lectures on contract law part 2, I would advise against it. Go and look at the contract part 2 lectures, especially the lectures covering lien, right? The lectures covering bailment. Okay, some of those lectures really lay the foundation for the Transfer Property Act. Okay, now you have a piece of property. Okay, you have a piece of property, right? You want to buy it, right? You're going to pay more than 100 rupees for it, right? The seller and you, the purchaser, you're the purchaser, you're buying it from the seller. You and the seller enter into a contract. You enter into a contract, and in that contract are the terms of sale. But that terms of sale, the contract of sale, is never registered. There is no sale deed. Value of the property is more than 100 rupees. What happens in such a scenario? What happens in such a situation? Well, as section 54 states, in a contract for sale, right, it states the terms on which the sale is to take place, but does not ipso facto create any interest in or a charge on or over such property. What does that mean? You may sue for specific performance of that agreement of sale. So you say, sir, I have an agreement of sale. Why doesn't it create an interest or a charge over the property? Very simple, because of section 54. You have a contract of sale. Approach the courts. Ask for specific performance of the contract. Okay, specific performance of immovable property. Ask that that property now be conveyed to you in accordance with the terms of that sale. When that property, right, is conveyed to you, right, the contract of sale will not suffice. You need to have an instrument that is registered. That instrument that is registered is a sale deed. So you will have the contract of sale or the agreement of sale appended to the sale deed. Okay, the sale deed, right, appended to it is the contract for sale. In a scenario like that, you have to take both those documents, the sale deed and the agreement for sale appended to the sale deed, which is a part of the sale deed, and take it to the sub-registrar's office and follow the requirements of the Registration Act of 1908 and any requirements in that state as to payment of stamp duty. I hope that's clear. So if you do not do that, all you can do is sue for specific performance of the contract. You say, sir, I wanted to buy that acre of land for 1 lakh rupees. We signed a contract, right, a very detailed 25-30 page contract laying out the terms of sale. Okay, then the seller reneged on his promise to sell the property to me. What then, sir, are my remedies? Your only remedy is to approach the court, ask for specific performance of the contract. If the court decrees specific performance of the contract, then you will need to subsequently execute and register an instrument, which in this case would be a sale deed, and have that registered. So once, ladies and gentlemen, stamp duty is paid, then the document will be duly registered in the sub-registrar's office. More on the charges, more on the rates of stamp duty and the payment of registration charges and fees a little later. So I've more or less now laid the foundation for the first half of this lecture. Let us now look at the nature and scope of section 54, and very importantly in section 54, section uses the word a price part paid and part promised, okay, basically, which means, right, or which leads to the question, sir, can there be a sale of a piece of immovable property if a sale deed has been duly registered? Stamp duty has been paid and the sale deed has been duly registered. Basically, can there be a sale if, sir, the vendor has not received the entirety of the purchase money? It's a property which is worth 1 lakh. You've only paid 50,000. Let us say the buyer. You still owe the seller 50,000, but all the requirements of Section 54 and the requirements of the Registration Act 1908 and the Stamp Act of 1899 are satisfied. Okay, and the requirements of the Stamp Act in that state. So let's take Karnataka, my home state, the Karnataka Stamp Act of 1957. All of the charges therein have been paid. The document has been duly registered by the sub-registrar. Basically, a khatha has been issued. What is a khatha? In my home state of Karnataka, what did I tell you? A khatha is basically a revenue receipt. It's a record that the taxes on the property have been paid or are continuing to be paid on a yearly basis. Khatha is a document that is issued by a local municipal corporation, as I've told you in previous lectures, a very, very important document. Okay, so ladies and gentlemen, right, what then is the nature, scope and ambit of Section 54? Right, returning to my original question, is it sufficient if the price is part paid? The answer is yes, it is. Okay, why is that? Let's look at a case. It's on your screen. The case I'm looking at is Vidyadhar versus Manik Rao, decided by the Supreme Court at the turn of the millennium. The definition indicates that in order to constitute a sale, there must be a transfer of ownership from one person to another. That is, a transfer of all rights and interests in the properties which are possessed by that person are transferred by him to another person. Straightforward stuff. Now the part in bold and blue. The transferor cannot retain any part of his interest or right in that property, or else it would not be a sale. So it must be an outright transfer of ownership. Use that phrase in your examination. There must be an outright transfer of ownership, and the definition in Section 54 further says that the transfer of ownership has to be for a price paid or promised, or part paid and part promised. Price thus constitutes an essential ingredient of the transaction of sale. Nobody is saying that price is not an essential ingredient of the transaction of the sale. The price is the fundamental reason why the ownership in the property is being transferred to you. The words price paid or promised or part paid and part promised indicate that actual payment, and this is the important part, actual payment of whole of the price at the time of the execution of sale deed is not a sine non to the completion of the sale. Even if the whole of the price is not paid, but the document, that is the sale deed, is executed and thereafter registered, if the property is of the value of more than rupees 100, the sale would be complete. And there are a catena of decisions basically of the high courts in this country which state that even if the whole of the price is not paid, the transaction of sale will take effect and the title would pass under that transaction. Okay, pause it, read it carefully. I'm back on screen, ladies and gentlemen. So part payment of price, it's in the language of the statute itself, will suffice. And you would be well advised, if you have a client who's selling a piece of property, you would be well advised to tell him, please do not hand over possession of the property until and unless you have been paid in full. Okay. That might not always be practicable, but if he goes ahead and executes a sale deed and duly registers that sale deed, and the buyer pays the stamp duty, right? And remember, the duty, right, the stamp duty is always paid by the buyer. Okay, there is nothing in law. There is nothing in law restricting the seller from paying the stamp duty or asking the buyer or imposing a liability or a duty on the buyer to pay the stamp duty. But the contract of sale and the sale deed to which it will be appended will clearly state, and this is commercial practice, it is the buyer of the property who has to pay all registration and stamp duty. Basically, he has to pay all registration charges and any stamp duty due upon the property. To get the document executed and registered, right, is the duty of both the seller and the buyer. The seller must make himself available at the sub-registrar's office on the date appointed for registration of that document, but it is incumbent upon the buyer to tender that instrument basically for registration at the office of the sub-registrar. The seller must make himself available. Other than that, all of the other duties, right, for example, preparing the document, executing the document, paying the stamp duty, paying the registration charges, okay, taking care of any other fees, okay, any under the table transactions, unfortunately we have that in India, it's a reality of daily life, is all incumbent upon the buyer. So the buyer basically will negotiate, right, his price on the basis that he has to meet all of these charges. And in many instances, right, and the sub-registrar will turn a blind eye to this, and so will the income tax authorities, a certain percentage of the sale will be done in black. Okay, so you will usually take about 65 to 70% in white, and you will take the remaining 25 to 30% in black. Okay, there's a consideration of the circle rate, that is the guidance value that comes into all of it. So usually up to the amount of the circle rate or the guidance value, right, you will have the transaction in white, and anything over and above that will usually be in cash. This is a reality of life in India, and now you know why, because of demonetization, right, the property market was hit so badly, and there has been a major slowdown in the construction sector, and a good 2.5 years almost after demonetization, India is yet to recover. At least the property market is yet to recover. So, okay, it's incumbent upon the buyer. Now the question is, buyer has completed all his formalities. He has tendered the instrument for registration. Seller is present. Okay, the formalities of the Registration Act are satisfied, but he has not paid the price to the seller, right, in full. Let us say he has paid 50%. Usually what will happen in practical life, right, when my father sold a property, right, usually it would be a percentage that was handed over before execution, right, and a percentage will be handed over after registration of the document, basically. Now, if that percentage is not handed over immediately after registration, what do you have? You have litigation. Okay, so the question then is, did the parties intend to transfer title to one another? That is the question, and that is the test. The test is the real intention of the parties. Okay, the test is to see whether the transaction was such as to transfer ownership in the property from the seller to the buyer. Price is an ingredient, but nevertheless it is only an ingredient. It is not a sine qua non for there to be a valid sale. Say, sir, that means that I can just pay 50% of the price and not pay the rest? No. It means once you pay 50% of the price and the sale deed is duly executed and registered, you are now the owner of that property. But as we shall see later, for the unpaid price, the seller has two remedies. One, he has an interest or a charge, I should say, over the property to the extent of the unpaid price. And secondly, he may also proceed personally against the owner of the property once he has exhausted his remedies, right, his interest in the property itself. So there's 50,000, right? It's a 1 lakh sale. You have paid 50,000. The remaining 50,000 remains unpaid. The sale deed is duly executed and registered. What happens then? The seller has a charge on the property to the extent of 50,000 rupees. That is the value of the unpaid purchase price. Okay, that is the remedy. And if you have disposed of the property subsequently to a transferee without notice of the part payment thereof or the part performance thereof, you may not be able to proceed against that transferee because he did not have notice. And in such a scenario, you, the seller, will not be left without a remedy. You will be given the opportunity by the courts to proceed against the buyer in his individual capacity for payment of the purchase price, because at the end of the day, what has he done? He has violated the terms of the contract of sale, the contract or the agreement of sale which has been appended to the sale deed. So he is in essence in breach of contract, and the court will compel him to pay the remaining 50,000 rupees personally. Okay, even though you may not enforce the charge on the property because the property has now passed into the hands of a subsequent transferee who had notice, right, in such a scenario. I hope, ladies and gentlemen, that is clear. Okay, the real test is, as I said, the intention of the parties, and the court will have to look at whether the parties intended to transfer title. Let's look at the quote from Vidyadhar and Manik Rao. It's on your screen. In order to constitute a sale, the parties must intend to transfer the ownership of the property, and they must also intend that the price would be paid either in presente or in future. The intention is to be gathered from the recital in the sale deed, the conduct of the parties, and the evidence on record. Guys, this part in bold and black is so important. You must reproduce this in your exam. In order to constitute a sale, the parties must intend to transfer ownership of the property, and they must also intend that the price would be paid either in presente or in future. So either the price would be paid at the time of sale or in the future. And the intention is to be gathered, the intention of the parties is to be gathered from the recital in the sale deed, conduct of the parties, and the evidence on record. And applying these principles to the instant case, Justice Wadhwa, he might sound familiar. He is the judge who handed down the judgment in the Rajiv Gandhi assassins case. It will be seen, says Justice Wadhwa, that defendant number 2 executed a sale deed in favor of the plaintiff. He presented it for registration, admitted its execution before the sub-registrar, before whom remaining part of the sale consideration was paid, and thereafter the document was registered. The additional circumstances, right, the additional circumstances are that when the plaintiff instituted a suit on the basis of his title, based on the aforesaid sale deed, defendant number 2, who was the vendor or the seller, admitted in his written statement the whole case set out by the plaintiff, and further admitted in the witness box that he had executed a sale deed in favor of the plaintiff and had also received full amount of consideration. These facts clearly establish that a complete and formidable sale deed was executed by the vendors in favor of the plaintiff, and the title in the property passed to the plaintiff. Okay, pause it, read it if you have to. It's very straightforward stuff. Okay guys, now I'm moving on to a very important concept, that is the transfer of ownership by registration. It's on your screen. I'm quoting from the case of Suraj Lamps versus State of Haryana, and here we now start our part of the lecture in which we focus on the requirements of the Registration Act. How exactly do you go about registering a conveyance, right, of immovable property? Suraj Lamps, I quote, "The Registration Act 1908 was enacted with the intention of providing orderliness, discipline and public notice in regard to transactions relating to immovable property and protection from fraud and forgery of documents of transfer. This is achieved," and pay close attention now, "by requiring compulsory registration of certain types of documents and providing for consequences of non-registration. Therefore, Section 17, ladies and gentlemen, of the Registration Act clearly provides, and Section 17 of the Registration Act is the most important section in that act, clearly provides that any document other than testamentary instruments. So we are not here dealing with a testamentary instrument. What, sir, is a testamentary instrument? A will. We're not dealing with a will, we're dealing with a sale deed, which purports or operates to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of ₹100 and upwards, to or in immovable property shall be registered. To or in immovable property shall be registered. So important. Pause it, read it. I'm back in screen. So ladies and gentlemen, we now come to the Registration Act of 1908. What is the court saying in Suraj Lamps versus State of Haryana? They said the requirements of registration are needed to provide for orderliness. They are a bulwark against fraud and forgery of documents. If, ladies and gentlemen, you do not have the requirement of registration of immovable property, how exactly is a prospective buyer to know what his seller has been up to? How exactly is a prospective buyer to know that the seller actually owns the land to which he is claiming, over which he is claiming proprietorship, and over which he is now seeking to transfer in exchange for consideration, in exchange for a price to be paid? So how do you achieve that? You achieve that by having a requirement of registration from time immemorial, ladies and gentlemen, way back to before the British and even before the Mughals. There has been some form of title deeds. There has been some form of registration of conveyances of immovable property in this country. With the advent of the British, ladies and gentlemen, the registration of immovable property, the sale of immovable property was codified only in 1908. It's pretty late, isn't it? Considering, right, that the Contract Act itself, for example, was passed about 36 years before. So it's pretty late in the day, right? But the Act of 1908, right, was a act that basically said, look, here are the categories of transactions, here are the categories of documents that will need to be registered. If you do not register a sale deed, how exactly can you trace whether the seller has title to the land or not? And when, ladies and gentlemen, a sale is not registered, right, what does the Registration Act say? What are the consequences of non-registration? Let's look at that. It's on your screen. So Section 17, right, states that any document, that is any non-testamentary instrument, must be registered, wherein it creates a right, title or interest, right, in immovable property. That's exactly what a sale deed does. And Section 49 of the said Act provides that no document which is required to be registered under Section 17, right, if not registered, ladies and gentlemen, shall, right, affect any immovable property comprised therein or received as evidence of any transaction affected such property unless it has been registered, right? So Section 17 says that sale deeds must be registered. Section 49 says basically if a sale deed is not registered, right, it shall not, that sale deed shall not affect any immovable property comprised therein or received as evidence of any transaction affecting such property unless it has been registered. Okay, what does that mean? Pause it, read it. I'm back on screen. If you do not register your sale deed, you do not have title to the property, ladies and gentlemen. That is it, right, sir? Is that all? No. Here's what happens. We've done this in the previous lecture. Section 53A, Doctrine of Part Performance. What did I say? Yeah, you have entered into an agreement of sale, but the agreement of sale has not been registered. You have entered into possession. You have paid the price in full. You have paid the price in full. You have entered into an agreement of sale, but you have not used a lawyer, and unbeknownst to you, that agreement of sale under Section 54, that contract for sale under Section 54 is not sufficient to create any interest in or charge on that property that you have purchased. So, under Section 53A, Part Performance, ladies and gentlemen, you will be entitled to protection of possession. You will be entitled to defend your possession. But remember, Section 53A, ladies and gentlemen, is only a sword, it's not a shield. Okay, I beg your pardon. Section 53A is only a shield, not a sword. Let me say that again. It's only a shield, not a sword. You cannot use Section 53A to establish title. You cannot use Section 53A to establish title. Section 53A is only available to you when you have entered into possession on the basis of an agreement of sale which has not been registered. But from that written instrument, the agreement of sale, the terms of the contract can be ascertained with reasonable certainty. You have performed your part of the bargain. You have performed your part of the obligation. You have paid the price for that property. You have paid the price for the purchase of that property. You have discharged your obligations of the contract. You must have had that agreement of sale registered along with a sale deed with the particulars of the property that you are purchasing, but you have not done so. Therefore, sir, does that not mean under Section 49 of the Act, that agreement of sale does not affect any interest created in that property? Correct. And it cannot be received as evidence, right? Can I phrase that in a different way? So, sir, does that mean that under Section 49 of the Act, that agreement of sale which has not been registered cannot be received as evidence, right? Cannot be received as evidence, and as evidence of what? As evidence of creating an interest in immovable property. The answer is there is an exception under Section 49 for part performance. And there is an exception under Section 49 when there is a suit for specific performance of that agreement of sale. So when there is a suit for specific performance of the terms of the agreement of sale, or when there is a suit basically, right, asking the court to grant an injunction, right, against the transferor or anyone claiming under him from evicting you from the property, from defending your possession, there is an exception, and that agreement of sale can be received into evidence even though it has not been registered. That sale deed may be received into evidence if it has been executed even though it has not been registered. I hope that's clear. So these two species of specific performance suits and doctrine of part performance cases, agreements of sale, written instruments containing the terms of sale, wherein the terms of the sale may be ascertained with reasonable certainty from that written instrument. They may be received in evidence in suits for specific performance and part performance suits, basically wherein the party that has performed his part of the bargain, his part of the obligation, the purchaser has paid the purchase price in full, right? He has been under the mistaken assumption, basically, that he does not need to get his agreement of sale registered, and he has entered into possession, right, of the property. Okay, he may not be ejected from that possession if he files, right, or resorts to the remedy under Section 53A under the doctrine of part performance. He may protect his possession until the title to that property is litigated, and when the title to that property is litigated, ladies and gentlemen, the agreement of sale cannot be taken into evidence, cannot be taken into consideration as evidence. But if it is a suit for specific performance, basically, and part of the contract and part of the suit for specific performance will be calling for the execution of a sale deed and the registration subsequently of the sale deed. So therefore, even in such a scenario, that agreement of sale will be taken into evidence. So these two exceptions actually eat up the whole general rule, but these two exceptions are crafted and have been carved out because otherwise it would result in a great amount of prejudice to the purchaser who has paid his price and has entered into possession, or a purchaser who has entered into a contract for sale. So if you have entered into a contract for sale, there has not been a subsequent sale deed that has been executed and registered, obviously that contract of sale can be taken into evidence because it is a contract simplicitor, and in a suit for specific performance of a contract simplicitor, right, that agreement of sale can be taken into evidence and is an exception under Section 49 of the Act. But very important is the general rule in Section 17. Let's go reread that general rule in Section 17 and then look at the benefits of registration and the rationale underlying the rule in Section 17. It's on your screen. So Section 17 states basically that any document other than a testamentary instrument, other than a will, which purports or operates to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent of the value of ₹100 and upwards, to or in immovable property, shall be registered. And another general rule in 49 is that no document required by section 17 to be registered shall affect any immovable property comprised therein, or be received as evidence of any transaction affecting such property, unless that document has been registered. The exceptions to this general rule are in suits for specific performance and as evidence of part performance. So that agreement of sale, as we know from our lecture on section 53A previously, I'm just quickly back on screen to explain this. As we know from our lecture on section 53A previously, ladies and gentlemen, when you have entered into a contract of sale, you have performed your part of the bargain as the purchaser, you have paid the purchase price in full, basically, okay, and you have entered into possession of that property. That agreement of sale on the basis of which you have paid the purchase price and entered into possession may be taken into account as evidence of part performance of the contract, because that written instrument in the language of section 53A itself, as we saw in the previous lecture, ladies and gentlemen, mandates that such an instrument must be present, and if such an instrument is present and obligations under that instrument have been performed and possession has been taken by the buyer in part performance, then the buyer cannot be evicted. His possession, right, must be protected. He may use section 53 as a shield, but he may not use it as a sword to claim title. Yeah, that title will need to be litigated outside of section 53A, and in such a scenario, what would have come in handy? The sale deed being registered in the sub-registrar's office. Because the sale deed has not been registered in the sub-registrar's office, the buyer, even though he is in possession, is greatly disadvantaged, and he will have to go about proving that the agreement of sale was actually entered into, and the only missing ingredient was the registration of the sale deed, and then his title to that property, right, will be adjudicated. And in such a scenario, it would in essence be a suit for specific performance. He would ask for specific performance of the contract, saying, I have performed my part of the contract, which is payment of the purchase price, and now I ask the seller to assist me now in registering the sale deed. The seller must make himself available at the sub-registrar's office, right? The sale deed must be executed, must be tendered, presentation must be presented to the sub-registrar. The stamp duty, if any, and there'll definitely be stamp duty, must be paid. And once that has happened, registration process will be completed and a certificate will be issued by the sub-registrar. Okay, and the title deeds to that property will be handed over to the buyer. Okay, so this is the importance of registration. What then are the benefits of registration? It's on your screen. So, registration of a document gives notice to the world that such a document has been executed. Registration provides safety and security to transactions relating to immovable property, even if the document is lost or destroyed. It enables people to find out whether any particular property with which they are concerned has been subjected to any legal obligation or liability, and who is or are the persons presently having right, title, and interest in the property. It gives solemnity of form and perpetuate solemnity of form, right, basically to documents which are of legal importance or relevance by recording them, where people may see the record and inquire and ascertain what the particulars are, and as far as land is concerned, what obligations exist with regard to them. It ensures that every person dealing with immovable property can rely with confidence upon the statements contained in the registers maintained under the Registration Act by the sub-registrar as a full and complete account of all transactions by which the title to the property may be affected, and secure extracts/copies duly certified for a payment of a price. So guys, very, very lucidly put there by Justice Ravindran in the case of Suraj Lamps. What does the registration of document do? Gives notice to the world that a document has been executed, provides safety and security to transactions relating to immovable property, enables people to find out whether any particular property with which they are concerned, which they intend to buy or which they intend to enter into possession on the basis of a lease agreement, has been subject to any legal obligation or liability. Who are the persons having the right, title, and interest in the property? Most importantly, it gives a sort of solemnity to documents, right, which are of legal importance or relevance. It records them, it enters the record into a register maintained under the Act, and it serves, ladies and gentlemen, registration of sale deed serves as a full and complete account of all transactions by which the title of the property may be affected, and it allows any individual to secure extracts and copies duly certified pertaining to the property in question. These, ladies and gentlemen, are the benefits of registration. I'm back on screen. So, sir, are you really saying that the difference between a sale deed and an agreement, right, for sale or a contract for sale is simply that the latter, the sale deed, is registered, whereas the former is not registered? Not entirely true. Well, a very important factum, okay, that distinguishes an agreement of sale from a sale deed is the fact that a sale deed becomes a sale deed only after it is duly executed and the stamp duty is paid and it is registered, basically, okay, in accordance with the provisions of the Registration Act and the Stamp Act in that state. But there are certain things that go into a sale deed. There are certain contents of a sale deed, basically, that may actually differ from a contract for sale. What the primary difference between the two is that a contract for sale does not create an interest in or a charge on property, whereas a sale deed duly executed and registered creates an interest in or a charge on the property that is being sold. That is the fundamental difference. Okay, now I'm going to give you a quote again from the case of Suraj Lamps to ram home this difference between a contract for sale, that is an agreement for sale, an agreement to sell property, and a sale deed. What's the difference? It's on your screen. Again, Section 54 of the TP Act makes it clear that a contract of sale, that is an agreement of sale, does not of itself create an interest in or charge on such property. I've explained that now repeatedly. Okay, then Justice Ravindran looks at the case of Rambao Namdeo Gajre versus Narayan Bapuji Dotra, decided in 2004 by the Supreme Court. Okay, so what then did the Supreme Court hold in the case of Narayan Bapuji? They held protection provided under Section 53 of the Act. Now they're going back to part performance, right? Harking back to the illustration of part performance that I used earlier. Just follow along with me and I'll be back on screen shortly to explain. Protection provided under Section 53 of the Act to the proposed transferee is a shield only against the transferor. We know this. It disentitles the transferor from disturbing the possession of the proposed transferee who is put in possession pursuant of or pursuant to such an agreement. It has nothing to do with the ownership of the proposed transferor. The transferor remains full owner of the property till it is legally conveyed by executing a registered sale deed in favor of the transferee. Such a right to protect possession against the proposed vendor cannot be pressed in service against a third party. So a right to protect possession against the proposed vendor cannot be pressed in service against a third party. Okay, it is thus clear, and this is so important, that a transfer of immovable property by way of sale can only be by a sale deed, a deed of conveyance. In the absence of a deed of conveyance duly stamped and registered as required by law, in the absence of a deed of conveyance duly stamped and registered as required by law, no right, title or interest in an immovable property can be transferred. Any contract of sale, that is an agreement to sell, which is not a registered deed of conveyance, a deed of sale, would fall short of the requirements of Section 54 and will not confer any title nor transfer any interest in immovable property except to the limited right to possession being protected or preserved right under Section 53A of the TP Act. I want you to linger on this slide. I'm going to read it again from the top and I'm going to explain it part by part. Section 54 of the TP Act makes it clear that a contract of sale, that is an agreement of sale, does not of itself create any interest in or charge on such property. We know that. So a contract of sale or contract for sale or an agreement to sell, call it what you want, is not sufficient. You need a registered deed of conveyance, a deed of conveyance that is duly stamped and registered. Until that is done, the transferor remains full owner of the property till it is legally conveyed by executing a registered sale deed in favor of the transferee. Such a right to protect possession against the proposed vendor, ladies and gentlemen, cannot be pressed in service against a third party. Okay, such a right to protect possession against the proposed vendor cannot be pressed in service against a third party. It is thus clear that a transfer of immovable property by way of sale can only be by a deed of conveyance, that is a sale deed. In the absence of a deed of conveyance duly stamped and registered as required by law, no right, title or interest in any immovable property can be transferred. Any contract of sale, that is an agreement to sell, which is not a registered deed of conveyance, that is a deed of sale, would fall short of the requirements of Section 54 and 55. 55 deals with the rights and liabilities of the buyer and the seller, which we're coming to next, right? And it would fall short of the requirements of 54 because it's not been registered and it will not confer any title nor transfer any interest in any immovable property except to the limited right of protection of possession under Section 53A of the TP Act. Pause it, read it carefully. I'm back on screen. So guys, I've given you a lot of information in that previous slide, but it's very straightforward. What then is the fundamental difference between an agreement of sale or a contract of sale, basically, and a sale deed? The latter is duly stamped and registered. The latter is duly stamped and registered. The former is not stamped and registered. Because the former is not stamped and registered, it remains a contract and it does not become a deed of conveyance. Unless and until you have a deed of conveyance duly stamped and registered, you, the buyer, do not have the legal title to that property. You do not have the legal title to that property. I hope that's clear. So, sir, what then are the remedies of the buyer if he is in possession? If the buyer is in possession, ladies and gentlemen, he is entitled to have his possession protected, and he may not be ejected or evicted from the property under the doctrine of part performance, section 53A. This is how section 53A ties in with section 54. Okay, but if he has not entered into possession of the property, then there's no question of him resorting to section 53A. Then all he has is a contract for sale or an agreement to sell. Then all he will do then is institute a suit for specific performance of the agreement to sell. And he will state that under that agreement to sell, he has performed his part of the bargain, that is, he has paid the purchase price. He has paid the purchase price in full, he has not been able to enter into possession of the property, and because possession has not been handed over of the property, right, what then is the liability of the seller? What is he guilty of? He is guilty of a breach of contract. He is guilty of a breach of contract only. Therefore, there must be a suit for specific performance. And if the court decrees specific performance, once the court decrees specific performance in such a case, obviously then the next logical step would be, with the buyer having fulfilled his part of the bargain, having paid the purchase price, all that is left for the seller to do is to hand over possession. But before he does so, they will have to again go to the sub-registrar's office, and they will have to get that agreement of sale registered. It will have to become a deed of conveyance, and it will have to meet the requirements of a sale deed. There are certain specific things that need to be contained in a sale deed that need not necessarily be contained in an agreement to sell. An agreement to sell might merely state, I agree to sell a plot number so and so. Both parties sign over. What else do you need? You have an agreement to sell. Is that enough to constitute a sale deed? No. There's a lot more that needs to go into a sale deed, and then that sale deed must be duly stamped and registered, and only then does the buyer get title to the property. And if he's already in possession of the property, he will resort to section 53A first to protect his possession, and then he will institute a suit for specific performance of the agreement to sell, wherein the clause in that agreement to sell stated clearly that both parties will execute a conveyance, a deed of conveyance, and the buyer will bear all registration charges and stamp duty charges and whatnot connected with the registration of that deed of conveyance, and the seller will present himself at the office of the sub-registrar and ensure that he plays in his part in the execution or in registration of the sale deed. So then you basically have a twin strategy. If a client approaches you and says, sir, I am in possession of a property, I have paid the purchase price for the property, the seller and I entered into an agreement of sale, sir, but we did not get that agreement converted into a deed of conveyance, and there's obviously no registered, there's no stamp duty that was paid, the deed of conveyance was not duly stamped and registered. What, sir, are my options? You will tell him, first option, we will file a suit under section 53A, we will file basically a suit in the court, right, asking for an injunction. All right, we'll file a suit asking for an injunction. We will pray that an injunction be granted against the seller or anybody claiming under him from interfering with your possession. As we know, under 53A, it is only a shield, not a sword, and you don't have to wait for the seller or the transferor and someone claiming under him to actually attempt to eject you or evict you from the property. You may preempt that and approach the court and say, I've entered into possession. Okay, and you may ask for and enter into possession, and you say you have part performed your obligations under the contract, and you ask your possession to be protected. Once your possession is protected and an injunction is granted, then you have the suit for specific performance, where essentially the title to the property might be litigated, and almost certainly will be litigated. And the court will then look into that agreement for sale and see if the obligations under the contract were performed by you, the buyer. They will then decree a suit for specific performance and instruct the seller to assist and make himself available at the office of the sub-registrar, right, to duly execute that sale deed, right? And the seller, although the buyer, under the terms of the contract, the buyer is undertaken to pay the registration fees and the stamp duty that is due for the purchase of the property, the seller must cooperate, and the decree for specific performance will contain all of this. And then that suit for specific performance, once decreed by the court in the favor of the buyer, you will complete the formalities at the office of the sub-registrar. And once those formalities are complete at the office of the sub-registrar, you, the buyer, are now the owner. The legal title to that property vests in you. Okay? I hope that's clear. All right. Now, guys, I keep repeating everything because you really need to understand. Now, the next step in all of this is to understand what actually goes into a sale deed. What are the contents of a sale deed? How, sir, is stamp duty calculated? Some practical information that you're unlikely to be tested on, but I need to give this to you. So pay close attention, because you will need this if you become a litigating lawyer. It's on your screen. Okay, so Process for registration of sale deed. I've just taken this off the internet and I'm going to quote verbatim. The sale deed must be classified as either a deed of sale if the property is being sold, or as a deed of mortgage, obviously, if the property is being mortgaged or leased. We'll look at that in greater detail in the next couple of lectures. The sale deed must contain accurate information. Yeah, the sale deed must contain accurate information pertaining to the sale so as to enable a person to identify the immovable property which is the subject matter of the deed. A sale deed is incomplete if it is not accompanied by a sale agreement containing all the terms and conditions that have been agreed to by the buyer and seller. So the sale deed must be accompanied by a sale agreement. Okay, and it must contain accurate information pertaining to the sale so as to enable a person to identify the immovable property which is the subject matter of the deed. That is the most important requirement of a sale deed, and it is incomplete if it is not accompanied by the contract of sale. If it's incomplete if it is not accompanied by the sale agreement, basically. Okay, containing all the terms and conditions that have been agreed to by the buyer and the seller. The value of the property has to be estimated based on the circle rate or guidance value. So it's known as the circle rate or the guidance value, which is the minimum value set by the state government's revenue department or the local development authority at which the sale can occur in that area. The circle rates of the area and the actual price paid for the property are compared. While calculating the stamp duty, the higher of the two values, that is the circle rate and the actual price paid, has to be taken into consideration. Okay, while calculating the stamp duty, the higher of the two values, that is the circle rate and the actual price paid, has to be taken into consideration. Non-judicial stamp paper of the value so calculated has to be purchased thereafter. Subsequently, the deed has to be prepared and typed in stamp papers. The final step involved for getting the sale deed registered is to approach the sub-registrar's office in order to get the sale deed registered. The parties must be accompanied by two witnesses. I hope that's clear. Pause it and read it very, very carefully, ladies and gentlemen. I'm back on screen, so I've given you the process for registration of a sale deed. A sale deed, the most important aspect of a sale deed, ladies and gentlemen, right, aside from its form, is the substance. And the substance of the sale deed is that the property must be clearly identifiable by looking at the recitals in the sale deed. The recitals in the sale deed must be very specific as to the location, the nature, the size of the property. Okay, that is the big difference between an agreement to sell and the sale deed. You might have a simple agreement to sell, basically, all right, but the simple agreement to sell will not constitute a sale deed unless and until that sale deed contains information as to the property, the particulars as to the property itself. If you have looked at a sale deed, you will see that it will identify the location. It will say the length and the breadth by so many feet by so many square feet, basically 80 by 100, 200 by 100, you know, what have you. Okay, it'll have the location, it'll have the address, basically any plot number or survey number if applicable, right, in that city. Okay, so all of these identifying markers of the property will be contained in the sale deed. The sale deed will always have to be accompanied by the agreement of sale. So it's not as though that agreement, right, that sale agreement is inconsequential. It's very important because it is that sale agreement that contains the terms and conditions on which the property is being transferred. And we've looked at the importance of price in section 54, haven't we? So the payment of price, the payment of purchase money, it might state that the purchase money is to be paid after the sale deed is duly stamped and registered. Yeah, if the seller is willing to take that risk, well and good. Or it might say 50%, right, before the sale deed is stamped and registered, 50% after such formalities with relation to registration and stamp duty have been completed. And all of this information that's contained in the sale deed must be typed up on stamp paper. Today, ladies and gentlemen, right, we continue to have non-judicial stamp papers and judicial stamp papers. Judicial stamp paper is something you use when you pay court fees, something you'll be very familiar with if you go into litigation. And in the first couple of years of practice under a senior lawyer, payment of court fees is something you will be involved in when you're filing a fresh plaint. Now, the non-judicial paper basically is used for registration of a deed of conveyance. Okay, and these stamp papers, non-judicial now, is available online. In my home state of Karnataka, for example, they have I think almost all states now do have online or e-stamp papers. I might be wrong, do check, but I know that Karnataka is one of the first states to introduce this concept of e-stamp papers. They did it 10 years ago, actually in 2008, and they did it in response to a stamp paper scam by Abdul Karim Telgi, the Telgi scam. Go and Google that, a very, very elaborate scam wherein Abdul Telgi, now deceased, died a year ago, concocted, well, he was basically a counterfeiter, let's put it that way. He started basically manufacturing fake stamp papers. Stamp paper, right, counterfeit of stamp papers, a very serious offense, and he was sentenced to something like 30 years in prison, and he was sentenced to another extra 10 years for a separate scam, so something like 40 plus years in prison. And anyway, he suffered from AIDS and he had all sorts of illnesses, and he passed away in Bangalore Central Jail last year. So to avoid this counterfeiting of stamp paper, you have something now known as an e-stamp paper, non-judicial e-stamp papers. I've put that up on your screen for your reference. You can see it. So you see it says India Non-Judicial Government of Karnataka, and it would be e-stamp is what it would say below that. And you see it's, and I've put the rudimentary old stamp paper right on your right, and you can see the e-stamp on your left. It's much more modern. All of the information is digital. So you see it says certificate number, certificate issue date, account reference, unique doc reference, purchase by, description of document, description, consideration price, first party, second party, stamp duty paid by, stamp duty amount, percentage. All of that is contained. Very, very helpful little picture to keep in your mind if you're asked a question on registration and stamp duty, ladies and gentlemen. So what, sir, you've been going on about stamp duty. Can you tell us a little bit more about stamp duty? Yes, I can. I have put on your screen the stamp duty and registration fees in the state of Karnataka. There's stamp duty there for adoption deeds, for affidavits, adoption deed. Hey, we've covered that, haven't we already, if you remember? Yeah, in our lectures previously on family law. We've seen there an agreement in relation to sale of immovable property is what we're concerned with possession. The stamp duty there is 5% of market value of the property, and the registration fee is 1%. So 5% on market value, 1% on registration, and there is an additional 10% of cess and a 2% surcharge that is imposed on the stamp duty itself. So you take 5% of the market value of the property, and on that 5% of the market value of the property, there is an additional 12% that is imposed in terms of a cess and a surcharge, basically. So it's quite hefty. Okay, it's quite a big amount. I'm back in screen, and that is why you have your transactions in black, right? So if it's a 1 crore property, you would probably sell it, right, in accordance with the guidance value, the circle rate. The circle rate for that property will probably amount to about 60 lakhs. Now you have two types of circle rate or guidance value. You have a guidance value as to a plot without a building on it, and you have a guidance value with a plot with a building on it, basically. Okay, so the guidance value will be computed by the sub-registrar when you present the sale deed, right, for to be duly stamped and registered. He will calculate that amount, and he will tell you that this is the stamp duty that is due, the market value of the property. So let us say the guidance value is 60 lakhs, you sell the property for 1 crore. The guidance value is 60 lakhs, you sell the property for 1 crore. If the entirety of the 1 crore has been received by you in white, basically, you will pay stamp duty on the entire 1 crore amount. I hope that's clear. You will pay stamp duty on the entire 1 crore amount. Okay, if the guidance value is 60 lakhs and you sell the property for 50 lakhs, that is 10 lakhs under guidance value. What's probably happened is you have sold 50 lakhs, you've taken 50 lakhs in white, and you've probably taken 50 lakhs in black. In such a scenario, what will the sub-registrar do? I'm sorry, you might have sold it for 50 lakhs. But you have to pay stamp duty on the 60 lakhs. You might say, sir, but there may be a genuine reason why he might have sold it for 50 lakhs. Maybe he has not taken any money in black. Maybe he has sold it for 50 lakhs. Because he needs the money urgently. It's a distress sale, and that's why he has sold it under 10 lakhs under the guidance value set by the local corporation. Tough luck. In such a scenario, you pay the stamp duty on the 60 lakhs. So if it was 50 lakhs, your stamp duty is 5% of 50 lakhs. If it is 60 lakhs, your stamp duty is 5% of 60 lakhs. But because the guidance value of your property is 60 lakhs, even if you sell it for 10 lakhs, you have to pay stamp duty on the 60 lakhs. So stamp duty must be paid on the minimum guidance value or circle rate set by the local authority in that city or state or district, call it what you want. Okay, so that circle rate and guidance value is now rising and rising and rising. So what happens? They will take the amount of the circle rate of the guidance value in white, and generally the remaining over and above the circle rate of the guidance value will be taken in black. So a 1 crore flat, right, you will probably have a guidance value of about 60 lakhs. Let us say you take the 60 lakhs in white, they take the remaining 40 lakhs in black. Is that allowed? Is that illegal? Is that legal? It's illegal. Why? Because you're evading tax. You're not only evading stamp duty, you're also evading payment of income tax. Remember, right? Any tax from sale of property, yeah, you have to pay. You have to pay income tax, and as part of that income tax, you have to pay capital gains tax. Go and have a look at my lectures on taxation and capital gains to understand all of this. So you're committing various offenses, but Indian authorities will turn a blind eye to it. But if the guidance value, for example, of a particular piece of property is 60 lakhs and you have sold it for 30 lakhs, then you say, sir, it's okay. Stamp duty has to be paid on 60 lakhs anyway. But there is another thing there. There is another element thrown into the mix. You've avoided paying tax. You've avoided paying income tax, right? Basically. So let us say it's a 1 crore property which you sell for 30 lakhs. Guidance value is 60 lakhs. You say, okay, I'll pay the 5% stamp duty on the 60 lakhs. It's a distress sale. I've taken 30 lakhs in white, but you might have taken 70 lakhs in black, and the income tax authorities rest assured, will send you a notice, and your auditor will have to appear before them, and you've probably taken 70 lakhs in white, they will get you. The taxman will get you, right? Two things certain in life, death and taxes. Okay, so my advice to you, when you're selling property, please try to take as much as possible in white. It's impractical to say take everything in white because you won't find a buyer. Okay, I have recently come across a transaction for 10 crore rupees of a property in Bangalore. A few uncles of mine sold it completely in white, 100% in white, basically. So 10 crores, guidance value doesn't matter. It's well above guidance value. It is fully in white. Okay, it's a fair price, arm's length transaction, basically. Okay. Fair transaction. So 10 crores, they had to pay a stamp duty of 5%. Who has to pay? Buyer has to pay. Buyer is willing to pay in white. Buyer is willing to pay in stamp duty. Nothing like it. Right? Why? What's the problem? Pay your 30% of income tax on it. So 10 crores, or it was about 9 crores, I say, divided by 3 of them, 333, basically. But that price, ladies and gentlemen, right, he would take away the payment of the stamp duty from it. He say, okay, agreed price is 10 lakhs, 10 crores, I beg your pardon. The payment of stamp duty is 5%, which is, how much is it? Yeah, my math, 50 lakhs, basically. Okay, so it's 50 lakhs is the stamp duty on that. So he'll say, okay, so we'll agree on a price of 10 crores, stamp duty is 50 lakhs, I got to pay registration of another 1%, which is another 10 lakhs, so that's 60 lakhs. And on the stamp duty of 50 lakhs, there's a 12% surcharge and cess. So 12% of 50 lakhs would be 5 lakhs, 10%, 5 lakhs, and 6 lakhs. So 56 lakhs, 5.6%. So stamp duty essentially in the state of Karnataka is 5.6% plus 1% registration, 6.6%. 6.6% will have to be paid by the buyer. 10 crore transaction, 6.6% in stamp duty and registration fees. Okay, so how much is that? 6.6%, 66 lakhs. Yeah, he has to pay 66 lakhs basically. So the amount remaining will be 9 crores 34, and that 9 crore 34 divided by the 3 of them, 3 crores and 11 lakhs each. That's how probably I would, or you should negotiate a transaction if you're paying all in white. Very, very rare to find a buyer who is willing to pay all in white. Okay, and if he is, then all of it, ladies and gentlemen, irrespective of whether it is above the guidance rate or not, will be subject to stamp duty. If it is below stamp duty, then he has to pay the minimum stamp duty, that is the guidance rate or the circle rate of that locality set by the authority concerned. Okay, so with that, basically, I hope you're able to understand what actually goes into a conveyance, right? A deed of conveyance, what is the meaning of stamp duty, what is registration, what is the importance, the benefits of registration and stamp duty, how the doctrine of part performance interacts, right? How the doctrine of part performance interacts with this concept of sale under section 54. Okay, all of that I've laid out for you in this sample lecture. I hope you found it useful, and if you have, I'd urge you to subscribe to SLR, and in the next lecture, if you've already subscribed and you're watching these lectures, we will cover the rights and liabilities of the seller and the buyer. What are the rights and liabilities of the seller or the buyer, both before the completion of the sale and after the completion of the sale? What is before the completion of the sale, after the completion of the sale? What is this meaning of completion of sale? The sale is completed when under section 54, read in conjunction with section 17 of the Indian Registration Act, a conveyance, a deed of conveyance, a sale deed has been duly stamped in accordance with the Stamp Act of that kind of state concerned. Let's say it's in Karnataka Stamp Act 1957, and registered in accordance with the provisions of the Registration Act of 1908. Once registered, the sale is complete. But before the sale is complete and after the sale is complete, there are certain rights and liabilities of both the buyer and the seller. What are they? We're going to cover that in the next lecture.